YouTube, it's Tone. I'm back with another one for you today. This is a continuation of the creditors and their bonds. I'm gonna run down that as quickly as we can. So this one here, I think you'll like. So we'll start off here. It says auditor, an officer of the court assigned to state the items of debit and credit between the parties in a suit where accounts are in question and exhibit the balance. Under rules of civil procedure in many states, the term master is used to describe the persons formerly known as auditors, right? So that's going to be the magistrate, and they're basically what do you call it, like referees in the game, in the back and forth on the tennis court or the court of law, right? You guys are bouncing the ball back and forth to see who ends up fucking getting fucked out of the situation. When in all reality, you're the creditor. You are everything there. You know what I mean? You just don't know that. So here it says magistrate. Magister, a master from magia. Sorcery from Greek magia, the theology of magicians. So you see what they do here. It's all it really has to do with black magic and shit like that, ultimately, as you can imagine, because there's usually a full-grown man wearing a black dress, right? And you're supposed to take that shit seriously, apparently. But everything that they do is to mix you up, to confuse you, right? Because this is when they're able to suggest idiotic fucking bullshit options to you when you're kind of thrown off your thrown off balance a little bit, right? So that's when they're gonna be like, hey, look, also these are the options that we have for you. They're not gonna tell you what all your options are. They're gonna tell you what the options are that fucking benefits them, right? Because those are not your only options by any means. So voucher, a receipt, a quittance, or release which may serve as evidence of payment or discharge a debt or to certify the correctness of accounts. So just like when you're doing your taxes, the 1040V, the voucher and shit like that, that's going to serve as like a check or something like that too. Surety bond. The surety bond is used to subrogate liability, and subrogate something that you really need to get comfortable with knowing what that's about. And it's basically your your option to be able to pass the buck if you feel like you need to. Like when you're playing the hot potato game or something like that, and you know what I mean, and you're all throwing it around, nobody fucking wants it, the last person with it loses, or you're a rotten egg or some shit. You can do that. You can do that here in court too. Make them the fucking surety. Because, I mean, in all reality, you are the fucking creditor in the whole situation. And these people are your public servants. And they're trying to flip the fucking script on you to make you believe that you don't have any power. But you have all the fucking power that you need. And you can absolutely make them the fucking surety. Just walk in there. Try not to make a mockery of the situation, because you'll probably get slammed and shit. Because, I mean, you are in their place of business. Even though they are a foreign corporate entity, they essentially are running the show inside of that little building. And that's why they actually need to bring you into their fucking building to gain jurisdiction over you. Which is why I find it kind of funny that they think that they can be doing video conferences with people. How are you gaining jurisdiction with somebody over a fucking video call when you need to? That's why every time you get arrested, right, they're going to drag you into the courthouse, bring you up the fucking stairs in chains. You're inside of their building. This is how they're gaining the jurisdiction. They're fucking kidnapping you and bringing you into their fucking building to gain the jurisdiction. Now, how does that work when they're doing that shit on video? It doesn't fucking work. So that shit is all fraud. So anyway, the surety bond is used to subrogate liability from one party to another. It is similar to an indemnity bond. You can issue a surety bond to relieve someone who was in dishonor of potential financial damage. You can indemnify an honorable party who may have made a mistake by volunteering to be his surety when you don't have to be the surety to that. I mean, ultimately the state created the fictional entity that you're claiming is you, right? So whoever created it is going to have to be liable for that. The state created that fucking entity, and your mother did, or whoever the fuck signed that paperwork when you were born. They are the fucking surety, not you, right? So you can even make them surety when the contracts that you create. And you can make them the surety. You can make the governor the surety, the mayor, whoever the fuck you want, because they're all public servants. So you can make any of those people the surety. It doesn't have to be you, right? This is often the case with a judge. If you do this, you are moving into a creditor position because you are taking responsibility for the actions of another. 3 parties are requested. Number 1, the one who is volunteering to be the surety. 2, the debtor. And 3, the creditor. There can be more than one creditor and more than one debtor. Creditor status can change during the case. So when you move into dishonor at any point, you're immediately making the person who was the debtor the creditor. Just like whoever defaults or breaches a contract instantly becomes the debtor, and then the other party has the right to either wipe away the contract or rewrite the contract. Right? This is all contract law. So there can be more than one creditor and more than one debtor. Creditor status can change during the case. When you become the creditor, someone has to be the debtor. The prosecuting attorney signed the complaint, and there is not a bond in the case file, and there is no signed security agreement. He is going to be the debtor. The prosecutor is going to be the debtor, right? They're creating that fucking debt out of thin air, right? And using your trust to fund it. Was that authorized? Did you authorize them to do that? If he acts honorably and tells the judge he wants to settle the case and have it dismissed, he stays in honor. You have to authorize him to sign the check to settle the accounting, right? You can do that with a Form 56F fiduciary and go ahead and assign them whatever role that you want them to play in this whole fucking play, because ultimately it's just a fucking act. If he acts in dishonor, he is the one who will be left holding the bag. You can bond the parties and or bond the case, right? So you want to find out if the case is even bonded to fucking begin with. And if it isn't, you can go ahead and bond it at that moment, become the creditor, and dismiss the whole fucking case. Case closed. Right? So we'll go to the next slide. Suretyship. The relationship among three parties whereby one person, the surety, you, guarantees payment of debtor's defendant debt owed to the creditor, the plaintiff, or act as a co-debtor, a co-defendant. Generally speaking, the relation which exists where one person, you, has undertaken an obligation, and another person, the defendant, is also under an obligation or other duty to give energy/credit to oblige to the plaintiff. So, you have an obligation to perform under any certain contracts or something like that, right? That's all going to come into play here. So you're going to need that contract too, just as well. So, anytime they bring a claim to you, you're going to go ahead and want to see that wedding signed contract that they claim that you have, because understand that this is all a commercial action. It's a commercial claim, and in contract law, you have to have a signed wedding contract presented at each and every single meeting in order to even be moving forward, right? So that's what's going to create the obligation, is them is them showing that you actually have a contract with them. So who is entitled but one performance? And as between the two who are bound, you and the defendant, one rather than the other, should perform. Suretyship bond, a contractual agreement created by your mother's signature on the application for your birth certificate between the surety, you, the principal, the defendant, and the obliged plaintiff, whereby surety, you, agrees to protect the obliged plaintiff and the principal defendants defaults in performing the principal's contractual obligations, discharging debt, or in any way dishonors the plaintiff. The bond, your written word, is the instrument which binds the surety, you, right? So keep in mind too that your live certificate of birth is actually a bond with a value, and you can issue bonds based on the value of your bond, right? So the easiest way for me to create a value, because they like to keep that shit hidden and you got to go hunting for it and all that. You want to capture your person with a UCC1. That's going to put you in a position to create the value of the bond, and you go ahead and you create the value of the bond based on the lien that you place against it, because debt is money in this world here now. So the value of the lien placed upon your live certificate of birth is going to indicate the value of it, because debt is actually money. So say you put $200-300 million lien on your fucking birth certificate, that's going to be the value of the bonds that you're able to issue based upon the value of that. And that's how that works. So the surety bond is to be delivered to the one who dishonored you. It is wise to have evidence of the dishonor before you issue a surety bond. Satisfactory evidence could be a certificate from a notary after an administrative process has been completed to assure there really is a dishonor. You might just think that you would dishonor. If you are in dishonor yourself and you have not corrected the mistake, you are not in the position to be claiming you have been dishonored. This is a very narrow window. You must always approach equity with clean hands. The clean hands doctrine, right? And none of these people all move in fraud, and they just hope that you don't realize it, catch it, and you end up being the one holding the bag. That's what it is. but it's all really a scam from jump. The surety bond is also delivered to the bonding company if one is in dishonor. If the one that is in dishonor is a public officer with a bond, it is also to be delivered to the clerk of court if there is a court case in process. Always get a certified copy of the surety bond from the clerk after it is filed. Right? So you wanna go ahead and I might even do a video on how to do the bonds and shit too. Cause that's something that you wanna definitely know how to do. Go there and issue instruments. Since this is all a commercial transaction, you can definitely issue commercial instruments. So case bond number 6. This bond is in the nature of a replevin bond. A replevin bond was formerly used in common law equity when there was a dispute after one party chose to file a claim in court against another party in possession of property in dispute. The moving party was required to bond his charged claim before he could get temporary possession of the subject and property. The replevin bond was double the value of the subject property. Part of it was to indemnify the sheriff who seized the subject property from the defendants in possession. The order part was to guarantee the defendant would be reimbursed at least for the value of the seized property if it were not returned to him in the event that he won the case, right? So everybody has to have skin in the game. It's like, all right, you people over here making all these fucking claims, what the fuck are you putting on it? Because I'm over here right now risking my fucking freedom, right? And my fucking bond. What the fuck? What skin do you guys have in the game, right? You just gonna fucking play for free? Absolutely not. Make these fucking people put whatever claims that they're making against you in the form of an affidavit signed under the penalty of perjury, right? And that's gonna fucking relinquish them of all their fucking what do you call that shit? Immunity that they're operating under, right? Because you're not holding them fucking accountable. So ask them what the fuck skin do they have in the game? Because I'm more than happy to play for fucking keeps, right? You want to fucking play these games? Put your motherfucking money where your mouth is then. You know what I'm saying? Because they make a lot of fucking claims and they have no fucking skin in the game. There's no chance of any consequence for you. And you want me to fucking play that game? Get the fuck out of here with that dumb shit. That shit is fucking retarded. Straight the fuck up. So, in equity, all charges need to be bonded. You have heard put your money where your mouth is. Abso-motherfucking-lutely, right? That is what is happening when charges are brought in court and they are moving party bonds the case. The policy assures that the defendant will not be damaged by an unsupported complaint, right? And then you have people making claims in fucking court that are not even first-hand witnesses. They're third-party collectors, and this is why I'm telling you that 15 USC applies in court, because it's unfair debt collection practices and they're fucking forcing you to pay in a certain species of currency, which they are not fucking allowed to do, and then they're acting like they're a fucking governmental agency. Well, how's that when you're a third-party collector? Because everybody in that fucking room is a fucking third-party collector and not a first-hand witness to any of the fucking facts, but you're out there yapping them in the middle of the courtroom like you know what the fuck you're talking about. You weren't even there. What the fuck are you talking about? You know what I'm saying? So this is why you're going to have to make them put that shit into an affidavit, sworn under the penalty of perjury, and as soon as they do that, you know they're lying because they were not there. That's a felony. So charges are rarely bonded in modern court procedures until after the case is decided. By that time, the defendant is almost always in dishonor, so the prosecuting attorney can use the defendant's dishonor to bond the case, right? So then they're going to use your fucking funds out of your trust to bond it because, come on. It is really the defendant's representative that is bonding the case. Again, it is the man's credit that gives life to the bond. If the defendant is in dishonor because of what his representative trustee said or did not say or did not do, it is the trustee's credit that is used to satisfy the debt, discharge the bond. Just like when they fucking release you on $5,000 fucking bond PR, right? Boom. They're fucking taxing your fucking estate already for the 5 or 10,000 PR that they're fucking letting you out on, right? They're just not telling you that. So they'll be like, yeah, you can go home, $10,000 fucking personal bond, and you throw on a fucking ankle monitor, and we're gonna tax your shit for 10 grand. You just want to get out, so you're like, yeah, okay. You can voluntarily bond the case if there is no bond already in the clerk's file. Be sure to get a certified copy of the docket sheet as evidence that there is no bond in the case before you issue your bond. When you bond the case, you are the creditor and the creditors win, right? You can close the case at that point. If you bond the case, become the creditor, and the dishonor is the judge, the attorneys, or the process in any way, you will lose your position as creditor and go back into the representing the defendant. All the dishonors are pinned on the defendant, even if you are the one who went into dishonor through your words or your actions. The defendant cannot talk or act. It all comes from you. So some interesting things to keep in mind there, right? But that's their goal, to try to get you to slip up. If you bond the case and underwrite all the obligations, lost costs, and the honorable citizens of the state of whatever it may be, that would include the attorney, as long as he is honorable. If he is not, he refuses to the indemnification and volunteers to have his dishonor give him the commercial energy to the settlement. It is up to him. The judge will go along with what he requests. Usually the attorney will tell the judge that the plaintiff moves for dismissal. Number 7, performance bond. Performance bonds guarantee that the parties to a contract will not be damaged by the conduct or lack of conduct of an officer. This could include an executive, trustee, officer of a court, officer of a corporation, guardian, etc. Wherever there is a fiduciary duty, there may be a need for a performance bond. An oath of a performance bond in common law, right? So in the modern states and integrated court systems, bonds are backed by insurance companies. They're actually insurance policies, and they are insurance policies, and you can get their bonds too. You always want to make sure you go ahead and find their bonds, locate them, accept them for value, and place them into the court as evidence too, just as well, right? This is gonna and let them know that, you know, in the case of their what do you call it, maladministration of your trust, that you plan on going ahead and placing a claim on their bond for whatever the damages are, whatever the price is that you say it is, whatever you feel like it should be, right? Since they want to be playing games. So performance bond, the type of contract bond which protects against loss due to the inability or refusal of a contractor to perform his contract. Such are normally required on public construction projects. Official bond, a bond given by a public officer, condition that he shall well and faithfully perform all the duties of the office, right? And they do have duties to fucking perform in a certain manner, in a certain fashion. So you have to hold them to it. So, but the only way you can hold them to it is if you know what they're supposed to be doing, because then you can be like, hold the fuck on, you're acting out of fucking character, right? Get the fuck back in line. Contractor, one who is in pursuit of independent business, undertakes to perform a job or piece of work, retaining in himself control of means, method, and manner of accomplishing the desired result. So, you know, these are all some of the underlying principles. You know, essentially it's going to be that, what do you call it? That these are all commercial actions, right? So in order to operate properly in commerce, if you ever feel like you're going to be in a situation like that, is to understand what the underlying principles are. And what it really comes down to is contracts. Shit is all contract law. They can't force you to fucking do anything, but they can trick you into a fucking adhesion contract by answering the question the wrong way or doing the wrong thing when you're in there thinking you fucking know what you're doing. You probably think you know what you're doing because you've seen this shit on TV so many times. This is how they program you to fucking act a certain way. When you meet, when you see cops or you go in the courtroom and shit like that, they programmed you through all these fucking stupid ass movies and shit like that. So that is why you act how you do, right? And so the only real way to walk out of there with your fucking integrity and your sovereignty that you walked in there with is by knowing who you are, by knowing who they're not, and knowing what the fucking rules to the game are. Because it is a game of chess. Stop fucking playing checkers. That's what I got for you for now. Until we meet again.